Allow the judgment to handle the body. It's okay. Off your mind. It's okay. She off your mind. Like me.
Chai! Now wow, people wey supposed talk truth to power don't off mind. And if we talk, now 500,000 they go summer us, call them hate speech. But fear not, my ego don't come. Ingo torchlight every corner, nooks and cranny of all these bad people where they spoil our country. So my people make we laugh, oh, yo. My ego don't come, oh, yo. My people make we shout, oh, yo. My ego don't come, oh, yo. My ego don't come, man of the masses, oh, yo. My ego don't come, oh, yo. My ego diary politico, yo. My ego don't come, oh, yo. This one not the off in mind, oh, yo. My ego don't come, oh, yo. Can in the touchlight every corner, oh, yo. My ego don't come, oh, yo. Okay, some people be they holla say they want the power. Chai, them be promise us say we go get light and power. Them hustle sote they can't get the power. But now they know they do anything with the power. Every day, dollar just they get it higher power over naira. See them talk say make we off mind, but thank God say my ego don't come. So my people make you laugh, oh, yo. My ego don't come, oh, yo. My people make we shout, oh, yo. My ego don't come, oh, yo. My ego don't come, man of the masses, oh, yo. My ego don't come, oh, yo. My ego diary politico, oh, yo. My ego don't come, oh, yo. This one not they off in mind, oh, yo. My ego don't come, oh, yo. Person where they do evil, no one make person talk. Them say that my egun, that man too they talk. He too they talk. Say my egun diary, he they hot like pepper. But every day then they take money in bulk. Poor man picking, they the street they hawk. Still them talk say make we no talk. But thank God say my egun don't come. So my people make you laugh, oh, yo. My egun don't come, oh, yo. My people make you shout, oh, yo. My egun don't come, oh, yo. My ego don't come, man of the masses, oh, my ego don't come, oh, yo. My ego diary politico, oh, yo. My ego don't come, oh, yo. This man not the off in mind, oh, yo. My ego don't come, oh, yo. Aha. Now you not done here, all these bad politicians, then we call themselves politicians. Where they thief our money, we no want make the common man get waiting supposed get for this country. Una never hear something. Now go hear one, my ego. You go show na paper. My ego diary political. So my people make you shout, oh, yo. My ego don't come, oh, yo. My people make we laugh, oh, yo. My ego don't come, oh, yo. My ego don't come, man of the masses, oh, yo. My ego don't come, oh, yo. My ego diary politico, oh, yo. My ego don't come, oh, yo. Ha, this one not they off in mind, oh, yo. My ego don't come, oh, yo. Mayegun la wa mo, la mo do. Mayegun diary, Mayegun number one. Mayegun la.
Hello there.
Mayegun diary, Mayegun number one. Mayegun ti de o, ọ̀rẹ́ ara yìí. Mayegun diary, Mayegun number one. Lórí Facebook, lórí YouTube. Mayegun diary, Mayegun.
Good morning to you. Good afternoon to you. And good evening to you from wherever you are joining us. It is brunch time with Mayegun. live. Please read the caption of the broadcast, like it, share it, invite your friends, invite your not so friendly friends, and tell them that Mayegu is live. If you have been following the media, for example, if you are already awake like us right here in Europe, Nigeria, possibly have heard that the action of Boko Haram's regime in 2021, when they connived with the Kenyan authority to kidnap Nnamdi Kanu, has backfired again. It has. A Kenyan High Court just ruled, and that is 3 days ago, that the abduction of Mazi Nnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, his abduction in 2021, June, by Malamu, the Attorney General to Boko Haram at the time. They committed an international crime, something that if people actually take it up with them, Nigeria should be sanctioned for such acts. It is all in an effort to have Nnamdi Kanu in their custody, like a trophy. Not because he did anything wrong. They sold a lie to the security and the government of Kenya. They said Nnamdi Kanu was meeting terrorists in Kenya. And when they found out that he wasn't, rather than let him go, they decided to hand him over to Nigerian agents with a private jet, and then a syringe in hand, drugged Nnamdi Kanu and bundled him straight to Nigeria for a crime that doesn't exist. So even in Nigeria, in their own court, he already has a judgment against them, which is over R1 billion on the abuse of violation of his fundamental human rights. Mazi Nnamdi Kanu, that you can call a cat with 9 lives, the bone that is tied around the neck of a bully dog. So the copy of that judgment, 64-page judgment from the Kenyan court that condemned that action of the Kenyan security agents, the government, and Nigeria. We have that copy on Mayegun's Diary Political this morning or this afternoon, depends on the time you are watching. Now, you know something about brunch time with Mayegun is that you can actually call in anytime. Also, after sharing the broadcast, right, you can listen to it like you are listening to a radio podcast, because it is the content of the judgment that we are going to read on this program today, and we are going to do it together. So if you have shared the broadcast, thank you. What today? So good morning to you once again, and welcome to the brunch time with Mayegun. Please give me a sec. I need to write. Just a moment, please. So we have a copy of Mazi Nnamdi Kanu's case against the government of Kenya and the authorities there that worked with the Bokuwari's government to kidnap him in 2021. Now, this case is specially instituted against them in their own court in Kenya. So it is from the Kenya High Court. A copy is currently public. Anyone who has a link, currently my hands are busy. So anyone who probably have the link should please share it in the comments, I would say. So we have a copy that if it was like individual versus individual, it would have been a case of criminal abduction. And that in itself, if found guilty, should guarantee a life imprisonment for such a perpetrator. But the plot to kidnap Nnamdi Kanu was between two countries, two presidents. And when I say two countries, that means two governments of two countries. Uhuru Kenyatta of Kenya, as well as Bokuwari of Nigeria. So it was at the time that Mazi Nnamdi Kanu, the leader of the IPOB, was demanding for a peaceful referendum to determine if the people of Biafra, the eastern part of Nigeria, they still want to continue to be part of Nigeria or not. Now, conspiracy thickens as interest, or vested interest started showing, their interest and plot to not only crush that advocacy, right, but to indeed kill the leader. That is Mazi Nnamdi Kanu. Now, they've spent a lot, not only in Kenya, across Africa, where they have collaborated with some of the despots, the dictators of Africa, to keep tracking him. So Kenya pretended to be lucky, in which we are not going to go into what they were given in exchange. But what did Kenya court, after listening to all parties, what did the Kenya court say in their ruling? So I'm going to ask you to please sit back, relax, and maybe we should. So right on your screen, sorry, brethren, one sec. So right on your screen is the copy of, the court ruling. This is from Kenya, or Kenya High Court. Right, I am going to skip and, okay, let's start from the first page, okay? So I'm going to skip and get to the point where the judge read out, his ruling. So here, Republic of Kenya, in the High Court of Kenya at Nairobi, Milimani Law Courts, Constitutional and Human Rights Division, Constitutional Petition number E359 of 2021. Kingsley Kanu, suing on behalf of and representing the subject, Nwanekaenevi Nnamdi Kanu as the petitioner, versus Cabinet Secretary, Ministry of Interior and Coordination of National Government, first respondent, Director of Immigration Services, second respondent, Director of Criminal Investigations, third respondent, Officer Commanding Police Division, Jomo Kenyatta International Airport, fourth respondent. So these are the people sued by Mazi Nnamdi Kanu. Then the Attorney General, fifth respondent. Now I am going to, like I said, I'm going to read this judgment while you sit back and, like I said, observe. At a point we shall open the line. Get what I mean now? So at a point we open the line, and let me frame my screen in such a way that will be easier for all of us. You get? Bear with me 1 sec. I'll take off the comment for now, okay? I'll come back to that. One moment. No, that's too like wide. Okay, let's get something else. I want to make sure that the center of your reading is the judgment on your screen. Do you get that now? So I can, my voice can come from the background. So just before I continue, because there's something about this. Normally, you have to put on your headset so that I can hear what's going on. So that's why I do ask people, since I don't do that, so I ask people to let me know if my voice and the audio is perfect before we get so fully into it. Because the next, I think, maybe the next half an hour, I am going to be reading through the judgment that Kenya High Court just delivered, against the Kenyan authority, and of course Nigeria too. But it is not just that judgment. If you want to if you want to be reminded rather, you will know that even the ECOWAS court, Mazi Nnamdi Kanu, has won Nigeria there, not once, not twice, 3 times. IPOB as part of the judgment against Nigeria, still on this matter. Okay, so thank you. If you can hear me loud and clear, then we are sorted. So let's get on with it. So the judgment, introduction. This is like the judge, what the judge delivered. It is a 64-page judgment. So so the introduction, anyway. So the first one, so introduction, 1. Kingsley Kanu, the petitioner, filed this petition on behalf of his brother, Mr. Nwaneka Envy Nnamdi Kanu, to be referred to as Mr. Nnamdi Kanu, for violation of his rights and fundamental freedoms. He served declarations of violation of the rights and order compelling the respondent to provide information regarding the arrest, detention, and rendition of the Mr. Nnamdi Kanu from Kenya, and an order for compensation. The petition is supported by 2 affidavits, one by the petitioner and another by Prince Emmanuel Kanu, Prince Kanu, another brother to Nnamdi Kanu, and written submissions. The petitioner's case. The petitioner stated that Mr. Nnamdi Kanu, the leader of a Biafra group calling for self-determination for Biafra land, is a British citizen who formerly held Nigerian citizenship, but renounced the Nigerian citizenship, and his Nigerian passport was taken away by the Nigerian authorities. On the 14th October 2015, Mr. Nnamdi Kanu was charged with terrorism-related offenses and incitement and detained for 2 years, but was released on bail in 2017 following an attack by the military of the federal government of Nigeria that killed several members of the Biafra party. Mr. Nnamdi Kanu fled into exile. On 12 May 2021, Mr. Nnamdi Kanu flew to Kenya from Kigali, Rwanda, and arrived at the Jomo Kenyatta International Airport on an East African tourist visa and stayed at Purple A's apartments, Kitale Lane, Nairobi, intending to spend a few days in the country before traveling to the United Kingdom. On the 13th of May 2021, Mr. Nnamdi Kanu was admitted at Nairobi Hospital due to a heart condition and was discharged on 14th, 2021. On 19th June 2021, He drove to Jomo Kenyatta International Airport to pick someone, but did not return to the place he was staying. This information was relayed to the petitioner by Mr. Nnamdi Kanu's secretary, Ms. Erina Notana Gitao, who also confirmed that Mr. Nnamdi Kanu's passport was still at the place he was staying. According to the petitioner, on 29th June 2021, the Attorney General of the Federal Republic of Nigeria addressed a press conference revealing that Mr. Nnamdi Kanu had been extradited to Nigeria. Cooperation between Nigerian intelligence services and Interpol. 7. Just a quick one, just for the record. In the course of this shameless, brazen abuse of power by Boko Haram and Nigeria in continuation Tifnumbu, Interpol had come out to say they had nothing to do with the arrest or the abduction, as well as the extraordinary rendition of Nnamdi Kanu to Nigeria. Just for clarity. So this Interpol being mentioned here is because Mr. Malamu, the criminal attorney general in Nigeria at the time, who broadcasted Nnamdi Kanu's abduction in Hausa language for the Hausa audience in northern Nigeria, said Interpol helped them. But no, Interpol said, no, we're not involved. No, they've already told court. Just for reference or for the record. But let's continue. The petitioner's case is that Mr. Nnamdi Kanu was taken to Nigeria contrary to the procedure set out in the Extradition, Contiguous and Foreign Countries Act. He was not shown a warrant of arrest, was not allowed to speak to his legal counsel, intermediary or family member. Mr. Nnamdi Kanu was also not allowed to challenge the lawfulness of his detention and subsequent removal from Kenya, and had never been classified as a prohibited immigrant in Kenya. The petitioner asserted that there were concerns that Mr. Nnamdi Kanu was being tortured while in detention in Nigeria, given the history of being tortured by the Nigerian authorities, thus putting his life in danger. The petitioner asserted that Mr. Nnamdi Kanu's arrest, detention, and removal from Kenya was done in violation of the Constitution of Kenya, the Fair Administrative Action Act 2015, the Extradition, Contiguous and Foreign Countries Act, and the Public Officers Ethics Act 2003. Prince Emmanuel Kanu, Prince Kanu, swore an affidavit stating that he had been authorized by Mr. Nnamdi Kanu to swear the affidavit because Mr. Nnamdi Kanu could not swear one since he was in detention and was prohibited from swearing an affidavit. Prince Kanu stated he had met Mr. Nnamdi Kanu on 27th July 2021 at about 3 p.m. at the headquarters of the State Security Services in Abuja, Nigeria, and he believed the facts given to him by Mr. Nnamdi Kanu to be true. Prince Kanu deposed that on 12 May 2021, Mr. Nnamdi Kanu entered Kenya legally as a British citizen and settled at a temporary location in Nairobi. On 19th June 2021, Mr. Nnamdi Kanu drove to Jomo Kenyatta International Airport on a personal errand. As soon as he parked the vehicle and alighted, several agents of the Nigerian government accosted and abducted him, handcuffed him, bundled him into a vehicle, and sped away. The abductors took Mr. Nnamdi Kanu to a house within Nairobi and chained him. They did not show him an arrest warrant issued by a court in Kenya or an extradition order. He was also not informed that there was a warrant or extradition order. Prince Kanu stated that the abductors beat Mr. Nnamdi Kanu in turns and tortured him while in chains until he fainted. Mr. Nnamdi Kanu was kept in detention for 8 days, was not allowed to bath or was fed, on stale bread once a day and given non-sanitary water to drink. His plea to be given medications for hypertension and heart condition were ignored. The abductors did not produce him before a court of law in Kenya or other law enforcement facility. He was also not allowed to contact an advocate or make a phone call to anyone. Prince Kanu stated that on 27th June 2021, Mr. Nnamdi Kanu was taken out of the house, put in a car, and driven to Jomo Kenyatta International Airport, where the abductors forcibly bundled him into a private jet that departed JKIA at about 12 noon and arrived in Abuja, Nigeria, in the evening of same day and was detained at the Nigerian National Intelligence Agency headquarters. On 29th June 2021, Nigeria's Attorney General addressed a press conference stating that Mr. Nnamdi Kanu had been rearrested through the collaborative efforts of Nigeria intelligence and other security services to continue with the trial he was facing before disappearing while on bail. Prince Kanu further deposed that on 22nd July 2022, the working group of the United Nations Human Rights Council issued a statement condemning the abduction, detention, disappearance, torture, and expulsion of, and called for Mr. Nnamdi Kanu's unconditional release and payment of reparations. The statement termed his transfer from Kenya an act of extraordinary rendition and required both Kenya and Nigeria to fulfill obligations to recompense him. Prince Kanu again stated that on 13th October 2022, the Court of Appeal of Nigeria termed the subject's expulsion from Kenya to Nigeria as an act of extraordinary rendition and discharged him of all criminal charges. The Court of Appeal also barred any Nigerian court from trying Mr. Nnamdi Kanu on any crime. It was again stated that on 26 October 2022, the Federal High Court of Nigeria also held that the abduction, detention, disappearance, torture, and expulsion from Kenya to Nigeria was an act of brazen violation of Mr. Nnamdi Kanu's fundamental rights and awarded him compensation. The continued detention in Nigeria was also declared unconstitutional. Mr. Prince Kanu asserted that Mr. Nnamdi Kanu believes that the government of Kenya had a duty to protect him as a British citizen, having been allowed to enter the country and been lawfully in the country. So the response. So the respondents opposed the petition through grounds of opposition. A replying affidavit sworn by Dr. Engineer Karanja Kibicho, CBS and written admission. Grounds of opposition. So here is what the representative of Kenya government and others put up as their defense against all of this petition, or against this petition. So in the grounds of opposition, the respondent contended that the petitioner had not satisfied the constitutional threshold in Anarita Karimi Njeru v. Republic, 1979 EKLR. There were no extradition proceedings to show that the government of Kenya was responsible for the extradition, and there is no OB record from any police station within, what the heck? Did they actually say that? Really? Okay. OB record from any police station within the country to show that Mr. Nnamdi Kanu was lawfully arrested and detained for purposes of commencing extradition proceedings. The respondents maintained that the petitioner, please bear with me. The respondent maintained that the petitioner, oh, that's not good. No, we need something soothing as a background, yeah? Something soothing, calm. I'm sorry. And a colorful too. Or maybe this. Let's leave this one. So they said the respondents maintained that the petitioner had failed to demonstrate with precision that Mr. Nnamdi Kanu was a person of interest by law enforcement agents. What the heck? Is this what their lawyers are in Kenya? Please pardon me, all right? Now, they asserted that, no wonder. So they asserted that some of the issues in the petition are on actions that took place outside the territorial jurisdiction of Kenya. How? It was the respondent's view that the petition is premised on hearsay because there is no evidence to show that Mr. Nnamdi Kanu was declared a prohibited immigrant under Section 33 of the Kenya Citizenship and Immigration Act 2011, or that a deportation order was issued under Section 43 of the Act. The respondents stated that the East African tourist visa issued in Kigali, Rwanda, was valid from 13th March 2021 to 11th June 2021. It was not possible for Mr. Nnamdi Kanu to be in the country on the same visa on 19th June 2021. It is the respondent's position that the petition had failed to demonstrate that it was police officers who arrested Nnamdi Kanu or that he was in custody of the Kenya authority. Thus, the petition does not raise a cause of action against the respondents. Replying the affidavit. It was deposed in the replying affidavit that the allegations of Mr. Nnamdi Kanu's arrest, detention, and extradition were facts not within the petitioner's own knowledge. According to the respondents, since 17th July 2019, Mr. Nnamdi Kanu had visited and departed Kenya on several occasions. His last date of arrival was 12th May 2021, and there is no evidence that he left the country. The respondent asserted that the persons who allegedly arrested Mr. Nnamdi Kanu had not been disclosed in the petition, neither at the place of his detention. The cooperation between the Kenyan and Nigerian government, as well as alleged extradition, had not been demonstrated and proved. They urged the court to dismiss the petition with costs. The petition was disposed of through written submission with written oral highlights. So the petitioner's submission. Do you want me to read that step by step, right? It's interesting though. So the petitioner's counsel submitted relying on the decision in Kituo Cha, Sharia, and 8 others, the Attorney General 2013 EKLR, that the subject having been within the territory of Kenya at the time was entitled to constitutional protection under the Constitution of Kenya. It was argued that the circumstances under which Mr. Nnamdi Kanu was removed from Kenya constituted a violation of his rights and fundamental freedoms guaranteed by the Constitution of Kenya, a breach of due process on extradition provided for in the Extradition Commonwealth Countries Act and the Extradition Contiguous and Foreign Countries Act. It also violated international law. The petitioner cited Article 21(1) of the Constitution, and the decision in CK, a child, through Repus International as our guardian and next friend, and 11 others, the Commissioner of Police / Inspector General of the National Police Services or Service, and 3 others in 2013. And these are cases, here you get, these are like cases referenced to by the petitioner, that is Mazi Nnamdi Kanu. It was submitted that Mr. Nnamdi Kanu, having lawfully entered Kenya, was entitled to the protections and privileges afforded by the Constitution of Kenya, despite not being a citizen of Kenya. Reliance was placed on the decision in SNV Cabinet Secretary for the Ministry of Interior and Coordination of National Management Services, Director General, Kenya Citizens and Foreign National Management Services, and Attorney General 2016. So this is them like, okay, referencing cases that protect Nnamdi Kanu and every other person who, even if they are not Kenyans, if they enter Kenya lawfully, they must be protected. in this instance. So they didn't. The petitioner again submitted that the conduct of the respondents and their agents in the disappearance of Mr. Nnamdi Kanu from Kenya fell outside their constitutional mandate and duty as envisaged under Executive Order Number 1 of 2023 and Section 24, 28, and 35 of the National Police Service Act, because the first and second respondent could not account for Mr. Nnamdi Kanu's removal from Kenya after his lawful entry into the country. The third respondent was complicit in the carrying out of an act of rendition in violation of the Constitution and laws of Kenya. So the petitioner relied on Article 10, 24, and 29 of the Constitution, Article 12.4 of the African Charter on Human and People's Rights, and Article 13 of the International Convention on Civil and Political Rights for the contention that these provisions require strict adherence to the laws of Kenya pertaining to the process of removing a person from the territory of Kenya and submitting him to the authority and jurisdiction of another state. The petitioner relied on Section 11.1 and 12 of Extradition Foreign and Contiguous Countries Act, Cap 76, and the decision in Gunter Groszowski v. Attorney General and Commissioner of Police of Prison, the Commissioner of Prisons 2009, to argue that due process on extradition was not followed. There was no warrant of arrest issued by a Nigerian court and endorsed by a magistrate in Kenya. Additionally, there was disregard of and non-compliance with Section 3, 5, 6, 7, 8, and 9 of the Extradition Commonwealth Countries Act. The court was urged to allow as prayed. So, respondent submission. This is the lawyers representing Kenya now in their response. The response submitted that the petition did not meet the threshold in Anarita Karimi Njeru v. Republic, 1979. They also argued relying on Rule 10.2c of the Protection of Rights and Fundamental Freedoms, Practice and Procedure Rules 2013, Mutunga Rules, that the basis of the petitioner's allegation was hearsay information from Mr. Nnamdi Kanu's personal secretary and Nigeria's Attorney General, thus of no probative value. The respondent further submitted that the affidavit sworn on 10th September 2021 and 28th March 2023 by Kingsley Kanu and Prince Kanu, respectively, amounts to hearsay because none of them witnessed the alleged event as deposed in the affidavit. The respondents maintained that no affidavit had been sworn by any authorized officer from Nairobi Hospital to confirm the authenticity of the annexure, which is annexure of KK4 admission form attached to the supporting affidavit. So they are questioning the hospital visit. So the respondent further argued that no report of a missing person was made at any police station, and there was no application for habeas corpus filed in court. They relied on the decision in Ruben Mwangi, the Director of Public Prosecution, and two others. So the respondent again argued that while Section 24E and G of the National Police Service Act confers on the third respondent power to detect, investigate, and prevent crime, that mandate is only discharged or exercised within the confines of the Constitution and the law. It is the respondent's duty to investigate if and when a complaint is made. They relied on the decision in Republic v. Commissioner of Police, blah, blah, blah. So there is more of their responses. Give me a sec. Okay, you know what? Let's keep going page by page. I don't want us to probably miss anything. Right. So this is them. So the determination. Upon considering the petition, so I want to believe that the determination is now the ruling, the judge. This is what they determined after listening to both parties, right? Upon considering the petition and argument by parties, the issues that arises for determination of whether Mr. Nnamdi Kanu's rights were violated, and depending on the answer to this issue, the appropriate relief to grant is violation of rights. So the petitioner argued that Mr. Nnamdi Kanu's rights and fundamental freedoms were violated because of the manner of his arrest, detention, torture, and transfer from Kenya. The respondents denied the claim of violation of rights and fundamental freedom. Okay, still kind of like putting them side by side now. To determine this issue, consideration of the facts on this petition is necessary. Some facts in this petition are undisputed, while others are. The undisputed facts are that Mr. Nnamdi Kanu is a British citizen of Nigerian descent. He lawfully entered Kenya on an East African tourist visa from Kigali, Rwanda on 12 May 2021 through Jomo Kenyatta International Airport. The following facts, however, disputed. According to the petitioner, Mr. Nnamdi Kanu was arrested or abducted on 19th June 2021 at the JKIA, Jomo Kenyatta International Airport, by people said to be abductors. He was taken to a house where he was chained, tortured, and subjected to inhuman and degrading treatment. He was denied basic necessities, including food and water. He was rarely given water to drink or bath, and was denied medication despite requests. After 8 days in captivity, on 27th June 2021, Mr. Nnamdi Kanu was driven to Jomo Kenyatta International Airport, put on a plane, and smuggled out of Kenya to Abuja, Nigeria, arriving in the evening of the same day where he was detained at the Nigerian National Intelligence Agency headquarters without extradition order. That's also a fact. Without, the court is now establishing all of the presented evidences now. You follow? Right. According to the petitioner, on 29th June 2021, the Attorney General of the Federal Government of Nigeria addressed a press conference and revealed that Mr. Nnamdi Kanu had been rearrested through the collaborative efforts of the Nigerian intelligence and security services so that he could be tried for the charges he was facing before disappearing while on bail. It was on that basis that the petitioner stated that Mr. Nnamdi Kanu believes that having been allowed to enter the country and being in the country lawfully, the government of Kenya had a duty to protect him, but failed. The respondent's position was that they were not aware of the claim that Mr. Nnamdi Kanu had been arrested or abducted, detained, incommunicado, tortured and taken out of the country to Nigeria. They denied that the government of Kenya was responsible for Mr. Nnamdi Kanu's transfer out of the country. The respondents maintained that there were no extradition proceedings to justify the government of Kenya's responsibility in Mr. Nnamdi Kanu's extradition. There is no OB record from any police station in the country to show that he had been lawfully arrested and detained for purposes of extradition proceedings. According to the respondents, since July 2019, Mr. Nnamdi Kanu had entered and departed from Kenya on several occasions, and his last date of arrival was 12th May 2021, and there was no evidence that he left the country this time. The respondent took the view that the petition is based on hearsay because there was no evidence that Mr. Nnamdi Kanu was declared a prohibited immigrant under Section 33 of the Kenya Citizenship and Immigration Act, or that a deportation order was issued under Section 43 of the Act. The depositions in the affidavit were made by persons who did not witness the events complained of. The respondents maintained that the East African tourist visa issued in Kigali, Rwanda was valid from 13th March 2021 to 11th June 2021, and therefore it was not possible for Mr. Nnamdi Kanu to be in the country on the same visa on 19th June 2021. Now, the respondent's position was that the petitioner had failed to show that it was Kenyan police officers who arrested Mr. Nnamdi Kanu, or that it was in the custody of the authorities in Kenya. It's a covert operation. They didn't declare him publicly. It was all illegal. So what were they thinking? So they are now doing the plausible deniability. I'll be waiting to call that thing. Let's just deny it. But I think the court could see it through them, if you probably ask me. Anyway, the undisputed facts in this petition are clear that Mr. Nnamdi Kanu entered Kenya lawfully on an East African tourist visa from Kigali, Rwanda, and stayed in the country for some time. The respondents admitted this fact, stating that his last arrival in the country was on 12th May 2021. They also stated that there was no evidence that he had left the country. The respondents admitted, therefore, that there was no record of Mr. Nnamdi Kanu. Mr. Nnamdi Kanu's lawful exit from the country. The respondent's position, again, that there is no record that Mr. Nnamdi Kanu had left Kenya seems to give credence to the petitioner's assertion that Mr. Nnamdi Kanu was abducted while in Kenya and taken out of the country. If that be not the case, the question then is, since Mr. Nnamdi Kanu entered the country lawfully on 12th May 2021 and had not left Kenya, where is he? Mr. Nnamdi Kanu, having entered Kenya lawfully, he had the right to remain in the country for the period his visa allowed him to stay. And in the event the visa expired, he knew what to do to extend his stay in the country while in Kenya. Mr. Nnamdi Kanu enjoyed the protection offered by the constitution and laws of Kenya. He was also subject to the laws of Kenya in the event he committed a crime. His presence in the country was indeed acknowledged by the respondents. The petitioner pleaded, averred, and deposed that Mr. Nnamdi Kanu was abducted on 19th June 2021 at Jomo Kenyatta International Airport by people said to be security agents from Nigeria and detained incommunicado for 8 days in a house in Nairobi. He was there after taken to Jomo Kenyatta International Airport and put on a plane to Abuja, Nigeria. On arrival, he was taken to that country's intelligence services agency headquarters. The respondents, of course, denied being aware of the alleged abduction or that Kenya was involved. The respondents again maintained that, indeed, Mr. Nnamdi Kanu arrived in Kenya on 13th May 2021, but there was no evidence that he had exited the country. So what happened? So the judgment continued. The respondent's assertion that there was no evidence that Mr. Nnamdi Kanu had left the country would imply that he was still in Kenya. If that were the case, the respondent had the ability and means to find out where Mr. Nnamdi Kanu is. Prince Kanu deposed that he met Mr. Nnamdi Kanu on 27th July 2021 at the Intelligence Security Services headquarters in Abuja, Nigeria, where Mr. Nnamdi Kanu was being detained, and gave him information on how he was abducted and taken to Nigeria. The information deposed by Prince Kanu corresponded with what the petitioner stated in the petition on how Mr. Nnamdi Kanu drove to JKIA, Jomo Kenyatta International Airport on 19th June 2021, only to be abducted while at the airport precinct. The petitioner gave details, including the time Mr. Nnamdi Kanu was abducted. Jomo Kenyatta International Airport is a high security area, and nothing can happen at the airport without being detected. If the respondents had interest to know what had happened, they would have known. The respondents, one of whom is the Cabinet Secretary for Interior, another officer commanding police station at Jomo Kenyatta International Airport, and the Attorney General, the principal legal advisor to the national government, would know what happened at country's premier facility if they wanted to. However, even with the averments and the position that Mr. Nnamdi Kanu was abducted while at one of the most secure facilities in the country, all the respondent could say was that the depositions were hearsay, while admitting that Mr. Nnamdi Kanu entered the country, but there was no evidence that he had left or exit from the country. Man, I actually love this Kenya. I mean, you know the film? I think I kind of like this Kenya because, listen, Kenya judiciary. Give me a sec. I'll see if I can come bigger so I can come closer to your screen. Kenya judiciary, right? I'm not saying maybe they are not corrupt or what have you, but you know that every time I hear that or I kind of like read about them in the media, it's always so positive. It's about something that they are standing up against the system. When this Gen Z decided to protest I'm sorry to just avoid a bit, okay, to deflect a bit, right? So I'm talking about their judiciary, right? Kenya Supreme Court stood behind the protesters in Kenya when Ruto was out there to kill and crush the protesters who are protesting the finance bill that last year. Yeah. They expected, they arrested a lot of people, took them before the court, and court released all of them. All of them. And at the same time, they wanted to declare that protest is illegal. The Supreme Court of Kenya came out and said, no, it's not. Let them express themselves. So when you now read the way this judgment is delivered, if you are reading like I am right now, I mean, you're going to agree with me that the wordings, which is the reason why I'm actually reading this, the wordings, the way they worded their judgments, Baba, you go no say, there is a certainty that you can get justice. That is not the contraption of Nigeria. Not that you don't have good judges in Nigeria, but they are corrupt enough that in a situation like this, they will be on the side of the criminal government. Yeah? Because how could you say somebody entered your country? Everybody knows that nobody can just pick a passport and go to anybody's country. And once you enter any country that you are a visitor, they know where you are. Some countries even have visas that you see at the port of entry, right? They can know who you're looking. America does that though. Like they will know wherever you are, everywhere you go to in that country, you are being tracked, they know you. How can you now go to the front of the court and say it is a hearsay that you don't know where this person is? So if you say this person hasn't left Kenya, he entered Kenya, but he hasn't left Kenya, then you have, they found him in Nigeria. And these criminals in Nigeria, they are thanking you that they work with you to abduct him illegally. No paperwork, no nothing. They took him to Nigeria. And all you could put up, your lawyer could put up in front of your own judge is to sound so dismissive and stupid as well. Like if you have been following the reading since, they call them respondents. They are like being so like, but you know what? Let's continue, okay? So, the judgment continues. I have read the affidavit sworn by Prince Kanu, a brother to Mr. Nnamdi Kanu. He deposed that he met Mr. Nnamdi Kanu in Abuja, Nigeria, where he was being detained. Mr. Nnamdi Kanu told him what had happened and how he was abducted from Nairobi, Kenya by Nigerian security agents and taken to Abuja, Nigeria. Prince Kanu deposed to facts as told to him by Mr. Nnamdi Kanu, who was being held in detention and could not therefore swear his own affidavit. In other words, the facts deposed to by Prince Kanu were on information given to him personally by Nnamdi Kanu himself. In that respect, the fact deposed in the affidavit could not be hearsay. The petition was also forthright that on 19th June 2021, at 12 noon, Mr. Nnamdi Kanu was taken to Jomo Kenyatta International Airport, put on a plane and taken to Abuja, Nigeria. Arriving in the evening of the same day, the petitioner's position, just like that of Prince Kanu, was that Mr. Nnamdi Kanu exited Kenya through Jomo Kenyatta International Airport after he was forced onto a plane and taken to Abuja, Nigeria, where he was detained. From these facts, there can be doubt that just like no one can enter the country through Jomo Kenyatta International Airport without documents or being detected, no one can depart through the airport, Jomo Kenyatta International Airport for that matter, without documents and or the knowledge of those responsible for the security of the airport and board a plane without being detected. The respondent did not dispute the fact that Mr. Nnamdi Kanu was taken out of Kenya through Jomo Kenyatta International Airport. Their position was that there was no deportation order. There was no record at any police station showing that he had been lawfully arrested and that the government was not responsible. The abduction and incommunicado confinement were not lawful acts, and therefore there could be no record on acts not sanctioned by law, given the respondent's admission that there was no deportation order in respect of Mr. Nnamdi Kanu. I find and hold Mr. Nnamdi Kanu, having not left the country voluntarily, he was forcibly removed from Kenya, and that is why there is no record regarding his departure or exit from Kenya. So, violation of rights. The next and most important issue is whether Mr. Nnamdi Kanu's rights were violated. The petitioner argued that Mr. Nnamdi Kanu was abducted without warrant and kept in a secluded house within Nairobi, where he was chained, tortured, and treated in an inhuman and degrading manner for 8 days. During the period, Mr. Nnamdi Kanu was denied food, water, and access to medication despite his health condition. The respondent denied knowledge of these acts. Mr. Nnamdi Kanu, having entered Kenya lawfully, was subject to the protection guaranteed by the Constitution and laws of Kenya. It was to be treated as required by the Constitution and laws of Kenya, since his rights were recognized and protected by the Constitution, and in particular, the Bill of Rights. It is in that respect that Article 19(2) of the Constitution provides that the purpose of recognizing and protecting human rights and fundamental freedom is to preserve the dignity of individuals and communities, to promote social justice and the realization of the potential of all human beings. Clause 3 thereof is also clear that rights and fundamental freedoms in the Bill of Rights, in quote, belong to each individual and are not granted by the state, and, again, in quote, are subject only to the limitations contemplated in the Constitution, of quote. I love this, right? Article 21 states, even more succinctly, that the Bill of Rights applies to all law and binds all state organs and persons, and that, too, every person shall enjoy the right and freedoms in the Bill of Rights to the greatest extent consistent with the nature of the right of fundamental freedoms. The Constitution is clear that the Bill of Rights binds not only state organs, but every person within the territory of Kenya. In that regard, Mr. Nnamdi Kanu's rights were recognized and protected by our Bill of Rights. He had the right to enjoy those rights and fundamental freedoms to the greatest extent possible while in Kenya. I love this.
Oh, you do IPOB. Oh, Mary, Mama Daura, Unapuri Mary Nnamdi win the war. Python that's 1, Python that's 2, now Python that's 3. Unapuri Mary Nnamdi win the war. Python that's 1, Python that's 2, now Python that's 3. Unapuri Mary Nnamdi go only do IPOB. O Mary Wonelizu Mbiroya Abakare Mama Daura Unapuri Mary Nnamdi win the war. Python that's 1, Python that's 2, now Python that's 3. Unapuri Mary Nnamdi win the war. Python that's 1, Python that's 2, now Python that's 3. Unapuri Mary Nnamdi win the war.
Bless you. Let's continue. The import of the above constitutional provisions, in so far as the petition is concerned, is that they fully applied to Mr. Nnamdi Kanu to the full extent as soon as he entered and remained within the territory of Kenya, whether lawfully or not. He was to enjoy his rights and fundamental freedoms and was to be treated fairly and justly as required by the Constitution and the law. If, for any reason, he was to be arrested, the arrest had to be lawful. Those arresting him had a constitutional duty to inform him the reason for the arrest and had to produce him in a court of law in Kenya within 24 hours following the arrest. Article 51(1) states in plain language that a person who is detained, held in custody or imprisoned under the law retains all the rights and fundamental freedom in the Bill of Rights, except to the extent that any particular right or fundamental freedom is clearly inconsistent with the fact that the person is detained, held in custody or imprisoned. Article 51(1) contemplates only situation where the person has been subjected to due process and is being held lawfully, and even then, the person retains all his rights, except those that he may not enjoy by reason only of being in lawful custody. In the case of Mr. Nnamdi Kanu, the averments in the petition and the positions in the affidavit show that he was abducted without warrant, detained, tortured, and later taken out of the country without any court order to that effect. The respondents admitted that there was no record in any police station that Mr. Nnamdi Kanu had been lawfully arrested. They also admitted that there was no deportation order issued by a court in Kenya. They did not argue that there was a warrant or order issued by any other court outside Kenya, or even a request from any country to surrender or extradite Mr. Nnamdi Kanu from Kenya. That being the case, no one had constitutional or legal mandate and power to arrest Mr. Nnamdi Kanu within the territory of Kenya, except those authorized by the laws of Kenya, namely officers from the National Police Service. Even then, they had to do so in compliance with the constitutional standards of human rights and fundamental freedoms, as required by Article 244C of the Constitution. The government of Kenya, through the respondent, did not show that there was reason for Mr. Nnamdi Kanu's arrest in Kenya, And if there was such reason, it was to be accorded due process and was not to be treated in a manner that violated his rights and fundamental freedom, since Article 22 of our Constitution recognizes rights of every person, so long as the person is within the territory of Kenya and abides by the law or laws of Kenya regardless of his citizenship. This position was reiterated in Moses Tengenya Omweno via Attorney General 2018 EKLR that one is entitled to due process irrespective of his citizenship. Article 12.1 of the African Charter on Human and People's Rights also provides that every individual shall have the right to freedom of movement and residence within the borders of a state, provided he abides by the law. In that respect, Mr. Nnamdi Kanu had the right to reside in and move around Kenya for the period he was in the country, as long as he did not break the law. When the Constitution speaks, it does so not as mere suggestions, but commands whose compliance is without questions. The Court of Appeal affirmed this position in Attorney General and two others v. Kituo Cha Sharia. Rights have inherent value and utility, and their recognition, protection, and preservation is not an emanation of state largesse, because they are not granted, nor are they grantable by the state. The court emphasized that under Article 20, the Bill of Rights, sorry, that one was loading up, so let's go to this 67. It said the Constitution enjoin every person to act lawfully insofar as rights and fundamental freedoms are concerned, bearing in mind the theme of maximization and expansion in matters enjoyment of rights and fundamental freedom. The fact of this petition, and more so the way Mr. Nnamdi Kanu was treated, point to a clear pattern of violation of the Constitution and the law right from the time he was abducted, held incommunicado and forcibly removed from the territory of Kenya. The government of Kenya owed Mr. Nnamdi Kanu a duty to respect and protect his rights and fundamental freedoms, including his personal security guaranteed by Article 29 of the Constitution. If he was to be arrested, there had to be justifiable cause for doing so. And even then, he was to be subjected to due process. Those involved were required to act within the tenet of the rule of law and human rights, foundational values in our Constitution. The rule of law requires that all public power be sourced in law, which means that state actors should exercise power within the formal bounds of the law. The abduction of Mr. Nnamdi Kanu, the way it was done without due process, is incommunicado confinement while in chains, his treatment, including being denied basic necessities such as food and water, denying him access to medication despite request, were acts that are outlawed by the Constitution of Kenya 2010. In that regard, I find and hold that there was gross violation of Mr. Nnamdi Kanu's rights and fundamental freedom. You know, when the judge will be like, this is my judgment. This is the part now. So they said this brings us to the issue of who should be held liable for the violations. The actions that led to the violation of Mr. Nnamdi Kanu's rights and fundamental freedoms were committed within the territory of Kenya, the country that had the duty to respect, uphold, and protect his fundamental rights and freedoms. The respondents denied knowledge of Mr. Nnamdi Kanu's abduction, his incommunicado confinement, torture, and eventual forcible removal from the territory of Kenya. They maintained that the government of Kenya was not aware and was not involved. If the respondents' assertion were to be believed, it would only show how perilous we stand as a country. That foreign agents can enter the country, conduct clandestine operations, abduct people who are lawfully in the country, hold them incommunicado, torture them, and take them out of the country through some of the most secure national installations without the knowledge of the government and those responsible for the security of the country. It is implausible that Mr. Nnamdi Kanu could have been abducted in broad daylight, held incommunicado in Kenya for 8 days, put on a plane at JKIA, and taken out of the country without the knowledge of the government and those in charge of the security of the country, including the airport. This court cannot accept that such acts could take place in an independent and democratic state governed by the rule without the knowledge of those in government. It is my finding, and I so hold, that the covert operation to abduct and forcibly remove Mr. Nnamdi Kanu from the territory of Kenya was done with the knowledge, connivance, complicity, and tacit approval of not only the government of Kenya, but also those in charge of the security of the country. The operation haven't been executed without any attempt to comply with the constitution and the laws of Kenya. The government of Kenya failed to respect, uphold, and defend the constitution of the law. Instead, it allowed violation of Mr. Nnamdi Kanu's rights and fundamental freedoms in breach of fundamental values of the rule of law, human rights, and accountability for which the government must be held liable. So here is the court relief, meaning since it has been established now that Kenya was involved, the violation, the torture, the abduction, and every other thing of Mazi Nnamdi Kanu in the last, for 8 days in Kenya, so they are guilty. Appropriate relief, as your lordship pleases. You all say that when I finish reading, okay, you say as your lordship pleases. Having determined that Mr. Nnamdi Kanu's rights and fundamental freedoms were grossly violated, the next issue is what relief should the court grant? This petition was brought seeking redress for the violation of Mr. Nnamdi Kanu's rights and fundamental freedoms enshrined in the Bill of Rights, with the belief that this court, as the protector of the Constitution and the fundamental values embedded in it, namely the rule of law, fundamental justice, and preservation of the democratic process, will respond and redress the violations. Article 23(3) of the Constitution vests on this court jurisdiction to grant appropriate reliefs, to redress violations of the rights in the Bill of Rights. The essence of such relief must be to ensure that the rights enshrined in the Constitution are protected and enforced. First v. Ministers of Safety and Security, 1997. Once the court finds that rights and fundamental freedom have been violated, it has an obligation to grant an appropriate relief as required by Article 23(3) of the Constitution. In cases of violation of the Constitution and fundamental freedoms, the court must consider whether an award damages as compensation towards the violation is the appropriate remedy. The state may be required to pay damages for making decisions that are plainly unconstitutional, are in bad faith, or an abuse of power. The petitioner has demonstrated that indeed Mr. Nnamdi Kanu's constitutional rights and freedoms were violated by the same states that is enjoined by the Constitution to respect, protect, and preserve those rights. The Tinyefuze v. Attorney General of Uganda, Constitutional Petition number 1 of 1996 to 1997, the Constitutional Court of Uganda stated that if a petitioner succeeds in establishing breach of a fundamental right, he is entitled to the relief in exercise of constitutional jurisdiction as a matter of course. In Canada, Attorney General v. Power 2024 SCC, Wagner CJ stated that Section 24(1) of the Charter, equivalent to our Article 23(3)(e), provides a personal remedy that is specific to the violation of an applicant's rights. a unique public law remedy against the state that should not be assimilated to the principles of private laws, remedies. Now, an award of damages remedy, an award of damages as remedy against the state for exceeding its legal power has long been recognized as an important requirement of, so they explain to people where they want bill now. So before they tell them what the relief will be, right? So the court is letting the Kenyan authority know that, listen, all over the world, what you just did, right? If it was an individual, you go do jail. But that's fine. But you have to compensate in the form of damages. It will never make up for what they did to Nnamdi Kanu. But the fact that right before their own very faces there, they are now seeing, that it is not just so many of us who have looked into all of this that believes that the injustice, the persecution of Mazi Nnamdi Kanu, right, would require reparation at a point. It's not something that should be swept under the carpet. So this is to go into the record as well. Now here, the court says, or ruled, in determining whether damages are an appropriate and just remedy, the court has to consider whether a constitutional right has been breached, whether damages would fulfill one or more of the related functions of compensation, that is, vindicating the right or deterring future breaches, and whether there is alternative remedy that would be effective than an award of damages and the appropriate quantum of damages. In this petition, rights and fundamental freedom have been violated. It was not demonstrated that there will be another effective remedy than an award of damages, quantum. The petitioner sought damages for the violations. Mr. Nnamdi Kanu was abducted on 19th of June 2021, held incommunicado, tortured, and subjected to inhuman and degrading conditions for 8 days in violation of the Constitution and the law before he was taken out of the country again without following the law. He is entitled to damages. When considering the level of damages to award, the courts should pay attention to the words of Patterson J. in Fuller v. AG of Jamaica, Civil Appeal 91 to 95, unreported, that where an award of monetary compensation is appropriate, the crucial question must be, what is a reasonable amount in the circumstances of the particular case? The infringement should be viewed in its true perspective as an infringement of the sacrosanct fundamental rights and freedom of the individual and a breach of the supreme law of the land by the state itself. But that does not mean that the infringement should be blown out of all proportion to reality. Nor does it mean that it should be trivialized. What his lordship Patterson J.A. Patterson meant was that compensation should be commensurate with the violation, since once rights are violated, they cannot be restored. Any compensation is merely of palliative value. So he went on to say more about the, So now I'm gonna, let's see what they have here. No, they're still comparing. So let's go to page 60, 87. Taking these awards into account, the nature of violation herein and considering circumstances under which the violations occurred, I considered an award of Kenyan shillings of 10 million fair and reasonable. So this is where the judge ruled that 10 million Kenyan shillings should be paid in damages to Mazi Nnamdi Kanu. Now, that is an approximately 120 million naira damages. So conclusion, having considered the pleadings and arguments by parties, the decision relied on the Constitution and the law, I come to the following conclusions. First, the government of Kenya violated the Constitution and Mr. Nnamdi Kanu's rights and fundamental freedoms Having entered Kenya lawfully, it was subject to the protection offered by the Constitution of Kenya 2010, and the government of Kenya had an obligation to uphold and protect its rights and fundamental freedoms. Mr. Nnamdi Kanu was, however, abducted, kept in solitude, confinement, tortured, and denied food and medication, a breach of basic rights. He was chained, humiliated, ridiculed, and held in contempt, and later forcibly removed from Kenya without following the law, in violation of his rights and fundamental freedoms, for which the government of Kenya is liable. So the poster, based on the above conclusions, the court makes the following declarations and orders it considers appropriate. 1, a declaration is hereby issued that the abduction of Mr. Nwaneka Nnamdi Kanu, holding him in incommunicado confinement, torturing him, and denying him food, water, medication, and other basic necessities, was a violation of his rights and fundamental freedoms. 2, a declaration is hereby issued that the abduction and subsequent forcible removal of Mr. Nnamdi Kanu from Kenya to Nigeria was in violation of the laws of Kenya, his rights and fundamental freedoms, including freedom of movement and security of the person guaranteed by the Constitution of Kenya 2010, and therefore unconstitutional and illegal. An order for compensation is hereby issued, awarding Mr. Nnamdi Kanu general damages of 10 million Kenyan shillings against the Attorney General of Kenya on behalf of the government of Kenya for the violation of Mr. Nnamdi Kanu's constitutional rights and fundamental freedoms. 4, the Attorney General shall also pay cost of the petition and interest dated and delivered at Nairobi this day, 24th day of June 2025. Justice E.C. Nwita, the presiding judge. Ladies and gentlemen. Now, I know that the criminals in Nigeria, they have done, they've done a great job on so many of you. That ordinarily, the moment you hear the name Nnamdi Kanu, you automatically just go into a complete episode, like into a feat. But, Baba, if this person has really committed any crime for real, why is it so difficult for the people who are telling you that he's done this, he's responsible for that and that? Why is it so difficult for them to follow due process, one, and at the same time, to actually present real evidence, not just what they are feeding into the media in order to justify their ethnic cleansing of the young Igbos in the eastern part of Nigeria? Because in case if you don't know, them spending so much to tell you that Nnamdi Kanu, IPOB is this, IPOB is responsible for that, this and that. Now, they have been losing in court wherever these allegations are brought up and challenged, right? They've been losing because they are supposed to present their evidence, Abi. If you say Nnamdi Kanu is responsible for this and that, and it's right there in your court, in your custody, it is time for you to now present this evidence to link Nnamdi Kanu to any form of violence. Everybody just goes into, all these people can be wrong. If there is something wrong somewhere that Nnamdi Kanu has done, right? Baba, all these courts, they can't all just be wrong. You know? So even if you don't like him, justice says, you know, it doesn't matter who that person is or how you feel about them. But you cannot illegally lock somebody up because you don't like them. And those who are sponsoring different kinds of violence in the eastern part of Nigeria, they are also funding the media push to at least keep the narrative this way. But it's not already sounding stupid now. Nigeria committed an international crime. They kidnapped somebody. Because they knew then that they would need to prove it in Kenya that Nnamdi Kanu committed any crime. How could you now go to Kenya? I mean, it was that bad though that Kenya court has no record that Nnamdi Kanu was declared wanted in Nigeria. Or there is a court in Nigeria that's order for his extradition or something. There's no record of anything. It was practically like, you know, the kind of what you call the drug dealers, terrorist kind of operation. She gets so criminal in nature. And today, the media is talking more about it. You get what I mean? So by the 18th of July, Mazi Nnamdi Kanu is expected to put up a defense in this same sham trial in Nigeria. Something that their own court, appeal court, said, Nnamdi Kanu, for kidnapping Nnamdi Kanu from Kenya, that is abducting him from Kenya to Nigeria, in the name of extraordinary rendition, that automatically makes any attempt of trying Nnamdi Kanu anywhere illegal. How is that difficult for anybody to understand? Like, you can't try him anywhere. You don't get it, Ni. You cannot try him in Nigeria. Before you can try Nnamdi Kanu for anything you want to accuse, you have accused him of, right? They would have to return him back to Kenya. A Nigerian court ruled that already. But they've made mess of your judiciary enough that, everybody's now just acting up like, I don't like him. Let him stay there. And then, since it is lawlessness, injustice, turn by turn, it is turn by turn Nigeria Limited. We are all talking out and speaking out now for Mazi Nnamdi Kanu. When yours happens, right? You may not have anybody to speak out for you. You may actually have to die, like, when nobody will hear until you are practically gone. They can't try him in Nigeria. That is what the law says. Because you cannot abduct somebody and say you want to come and try them. No. You first request the court in Kenya to extradite the person. You get? It is when the court now grants your wish. That is where you are now going to take the person and go and try them for whatever it is in Nigeria. But they know that they would have to prove it in Kenya that Nnamdi Kanu committed any crime. They will need to. We are looking for this person. So they didn't want that paperwork. They can't even forge the paperwork in their country. So they work with Uhuru Kenyatta, a criminal himself, right? God knows what they promised or what they gave him, all right? So they work with him and they made it a coded, what have you. You are not involved. But Malamu was in Nigeria thanking you for a job well done. I'll take a break. See, my own time is almost done. We can take a break and call it, we can call it an afternoon. Or we can probably take few calls that people react to this tonight. But whatever we decide, all right? I will be back in. Okay, let me stretch my legs. Don't go anywhere.
Godfatherism, kò sí lọ́rọ̀ Máyégún diary. Ẹ farabalẹ̀ sẹ́ o kẹ́kọ̀rọ̀ lẹ́yìn.
Thank you.
Lórí YouTube. Ọba bá gbé wúrẹ́.
Sorry about that. I think I was having problem with my network or something there. And I also believe I have a caller on the line. Hello there.
Hello, sir.
Are you still there?
I'm with you, sir.
Oh, brilliant. Sorry for keeping you waiting. You can hear me loud and clear, can you?
Very clear, sir.
Great, Baba. So everybody can hear you too. How you doing?
I'm great. I'm good. And how are you too, sir?
Well, surviving. Thank you so much for asking.
This is Kenny from Moscow, Russia.
Hey, Sir Kenny. How are you today?
Yes. I'm fine. Very, very much fine, sir.
Fantastic.
It's been a long time.
I know. I mean, you know, same old. Baba?
Yeah, you know, we people in this area, we always miss the night show most of the time due to the time change.
Yeah.
So, sometimes I actually watch it. I also actually watch the show whenever I'm at work the next day. If they want to pick up, okay, let me try. I'm going to be lucky. And I'm very, very happy that.
Oh, bless you. Like you can hear it live.
Live again.
I know. What time is it in Moscow right now? What time is it?
This is till 6. I
in
just
the evening?
From work now. Yeah, in the evening.
Oh dear. Okay, let's do it quickly then. So that, did you say you are just finishing from work or you're going to work?
Yeah, I just closed from work.
Oh, you just finished. You're going home. Now let's have this chat, Baba.
Yeah, I'm going home.
Yeah, so I have started coming on for our usual brunch time. Okay, so this afternoon.
You know, I always enjoy the brunch time. Like seriously,
you do.
That is the only means I have the opportunity to call in. So I'm always happy when I have that opportunity.
Now you are here, Baba. Please help us. Help us contribute to this.
A lot is always happening in that contraction. And like you said, you always advise us at least for our mental safety. Sometimes I just overlook because I'm hoping that one day they are going to meet their dooms. That is what I believe, that one day. It can't continue like this.
Like the people themselves, when they have had enough.
I don't believe. Yes, I don't believe. I know that one day, maybe, I don't know what is going to trigger it, but I just believe that you can't continue to enslave the people or just believing that okay, nothing they can do. Because this Tinubu regime is very, very terrible. The criminality is terrible. It's to the peak, like you always said. I know that one day, maybe we are going to save ourselves or God is going to save us, but we must be the one to save ourselves.
Must happen.
Because something must happen one day. That is my only expectation. And I'm always happy that we have people like you who are always giving us the truth, who is not relenting. Even when sometimes, human being, we must be somehow.
I mean, now we are all humans now. You feel down,
we're all
lift
humans.
yourself again. When it's time, take a break.
Your message for yesterday now, you said sometimes you feel down, but you still motivate yourself to come and give us that. These are our medicine, like you always know. These are our medicine. So, and we always encourage you in our own little way.
I know.
If I have 1 billion, like I'm ready to share it. Okay, let's share 50-50.
Yeah. See now. So you know something, You know something. What they say in Yoruba. So I want you to have that billions, okay? Because I can, even if you don't share it with me, but I'll be a friend of a billionaire. Do you get that now? So I can say, Kenny is a billionaire. So he's my friend. I'm a friend to the billionaire. Because they say your friend wants to be a king. You are opposing it. Don't you know that you said you won't be a king? I mean, the friend of the king.
You're a king friend. Yes.
You want to be a king's friend, then you must encourage your friend, support your friend to be that king. So I wish you all the best, Kenny. So thank you very much, Baba.
Thank you very much, sir. One last thing, sir.
Yes, sir, please.
I'm still waiting for the day that Nnamdi Kanu is going to regain his freedom. Because I know he can never be locked forever.
I know.
I'm still hoping. I'm still praying for him. Personally, I am praying for that man to regain his freedom. He's one of the icons that we look onto in that contraction, in that Nigeria. You are acknowledging. I pray that one day he's going to regain his freedom. You can never lock the truth. It's not possible. It will smoke out no matter anything. God bless you, sir.
And you too, Sakeni. Stay safe, God bless you. Here is Prince Adebayo from Sweden. You hope today, Baba.
My king.
The prince.
My king. Today I'm ready for you because I'm just happy
you have the mic then.
I'm happy that you're doing this again,
Bless you.
Baba, over the past few days, the kind of stories that have been coming out of Nigeria is just a testament to the fact that there is more than meets the eyes. Do you know that this Nnamdi Kanu case that we are just revealing now, the one that they are giving him a compensation from Kenya? Do you know that it is no longer ordinary? The people that are holding him there are not Buhari or Tinubu now
anymore.
It is the people that are the people behind this Tinubu, behind Buhari and Tinubu, because you know that when Buhari was there, you know that he could not stop the killing of his people, the unaliving of his people by these external forces. The same thing, Tinubu cannot stop the unaliving of his people. So you now tell me,
so
how can somebody
that means this powerful unseen hands?
Yes, there's an unseen hand, because that is why if you watch what is happening all over the country, people will come. All of a sudden, they just come demolish your house. They are taking people's properties everywhere. It's no longer. I think we need to have a meeting with people that have come to our side now, that have been there before. People like Olusegun Obasanjo and El-Rufai. Let them come and tell us what they know before they leave. There is something deeper, bigger than our presidents. They are just there to steal and then be ceremonial. You cannot tell me that Tinubu cannot stop the unaliving of people and the rubbish that's going on, even in his own southwest. You cannot tell me that Wike has mind that they will not take it. They will not take it back from him. That he stole how many hectares, how many plots of land and transferred to his children. And it's not,
all over
2,000. It's not even farm. 2,000 hectare plots for building houses. 2,000 is this small? It's like one small country for his children, and he believes that nobody will take it back from him. Baba Ewo now.
The prince.
Each time we start having meeting with these people like Obasanjo, let him tell us what he knows before he leaves. This El-Rufai, let him tell us what he knows. There's something they know that they are not saying. Baba,
Prince,
thank you so much for this afternoon, and I'm very grateful.
Yeah, let's hear from others too. Thank you very much. You know something about this streaming software. My caller, please hang in there for me for a second. Though. I noticed that. Do you see that? What's that called again? That QR code on the screen. Here, this one. You see this one here? If you bring out your phone and turn the camera on and you scan it, so it's going to give you a link. There's going to be a link that will pop up there. It is that, buy me a coffee link. And the funny thing is that every scan, right, is showing up on this screen. Somebody scanned that. That's why I mentioned it. It's quite funny. Hello there.
My dear.
Ma. How are you?
How are you?
I'm very well.
I'm fine, thank you.
Good.
Oh, in fact, Tony, money one kind of crazy like schedule. I know that I play this brunch time. Obama.
Right.
You understand? Yeah. During that noon, a lot of one be mainly concentrate like that because of what I'm doing. But in the morning, this time around, Obama.
Fitting up. Okay, maybe we can build the audience for it to some extent. If people who are missing out on the afternoon in America, for example, now, and those who are missing out elsewhere because of the time, right? They have something else that they can say. And this one is quite interesting too because it's an open mic, and any topic that comes up is to have people kind of like chip in there. So yeah, I'll keep trying it. Bless you.
Please, God bless you. Yeah.
Amen.
So,
you too, man.
Yeah. So what I really want to say is, in fact, this Nnamdi Kanu case that you're actually reading out is really, really an interesting one.
Honestly.
Sometimes I
Oh, hang on. Give me a sec. It seems that we're having fluctuating audio right now. So just don't worry. You just hang in there, okay? Then I'll ask our people to help us confirm if we are still good to go. So one sec. Brilliant. Sorry, ma'am. Please, listeners, can you still hear us loud and clear? Like the audio is still good, because I noticed that it got kind of like truncated a bit earlier. So I don't want us to keep talking and, sorry, please hang in there for me for a second, man. One sec. Yeah, if you can hear me clearly, for instance, the last person asking how can they call in? The number to call is on your screen. It is a WhatsApp number, by the way, +44777069222321. Use that. Anyway, let's continue. I don't think the audio has any problem so far. So, ma'am.
Okay, so please. Can you hear me good now?
Yes, ma'am. All of us can hear you now.
Okay, good.
Yes, ma'am.
So what am I trying to say? I said you think they don't know what they're doing? Let me tell you. You see when Kanu releases those the IPOB boys, his
the ESN,
his army, sort of the ESN. Oh, then I told my husband, I said, this is a big mistake that Kanu has made. It wouldn't have, Nigerians, they're always looking for a loopholes. Anything they see, right? That is they use it as a bait. You understand? So what? Ever since he released those guys, the picture when they saw them, that was when they've been like trying to make sure they get down because they know what he can do. Now they caught him, right? Court has released him for how many times, but they refuse to release him. Let me tell you, they know that if Nnamdi Kanu, they release that man today, you see all those terrorists that are in their bushes, all the East, I bet you there will be no more. That is what this government are fighting for. That they know that if they release this man, he will finish all of them.
They are asking him to, to denounce IPOB, to say he's no longer interested, and then they will let him go. And
why would
it was like,
it
was like I've been through a lot. Lost his mom, lost his dad, lost so many members of, and now you want me to just walk away? He said he would rather die. And I think that's the reason why they will let him. Yeah, they don't want him to just go like that.
Because they don't want him to, all those people that are in the bush, they don't want him to touch them. So you see the kind of government we have, all these controversial things. You see what they are doing. They are the ones putting those people there to be killing us, killing the people there. And at the same time, you don't want somebody that will come and rescue their people.
Yeah,
you don't want that person to be out. How do we even explain this? You carry terrorists, you forgive them, right? You put them in your army, you give them houses, you pay for their whatever. Then you carry the citizen, the one that is good, fighting for his people. You now put that one in jail. Please, how do we explain that?
It doesn't make any sense.
Is it synonym or anonyms? Not whatever names. How would I call it?
I know. Like, no, rationally, when you see rational thinkers, when they farabale and they are not speaking to emotion, right? When you just begin to look at things and be like, it's not hard to see. You can easily tell yourself, but this don't make sense. So even if you want to try to make sense out of it, you are still going to struggle. It won't make any sense.
See how terrorists are outside. Did you see the recent one? How they are outside saying they are being funded by the Nigerian politicians.
Yes.
How we saw the ones that police with their uniform on and their car went to meet them in the bush. Nobody, no letter, nothing. We did not hear anything. But look at the children that came outside in Benue to say no, enough is enough. 14 of them, how many of them right now?
They are still in prison right now.
How do we explain all this? And Nigerians and the government will come out and say we are doing everything to make sure they are outside there. If it is somebody that goes on TikTok now to say any sort of thing concerning the government, they know where they to find that person.
Straight up,
what person people go and look for? So why can't they go and look for all these? Nigerians should please wake up and see what is going on. They should please stop all this tribalism, religions and whatever, and face the real thing that is on ground. These people are unaliving all of their people. They refuse to leave the real one that wants to come and help them, and they are there facing, doing tribal, doing whatever. What is the name of that song that I normally play?
Everybody Masare, Iba Komade, Asiko Konshimbo.
Ìgbà yẹn dẹ̀ máa dé lágbára Ọlọ́run má ní wọ́n máa filẹ̀ o wọ́n á filẹ̀ lágbára Ọlọ́run.
You enjoy the rest of your money.
Ó bá mi kí Àbíkẹ́ o.
Yes ma.
Ó mọ̀ pé o ṣẹ̀ mi o wá sí Amẹ́ríkà ò dọ́dọ̀ wa kò dá báyìí.
Bẹ́ẹ̀ ilẹ̀ pè mí kẹ́tẹ̀ sọ pé wá má bọ̀ bí bàbá yìí o. Ẹnu ẹ má wọ̀rẹ́.
Mi ò rò bí ìwọ náà ló ní ká má pè é lórí nọ́mbà yẹn. Mo lè bẹ́ẹ̀ ṣe bẹ́ẹ̀ dè mí lọ́gọ̀t tó mo invite ẹ o.
Ẹ má bínú one, right? I will make sure that we accommodate all of that next time tí ò ní ṣẹlẹ̀ mọ́.
Okay. Ìjọba mi sọ fún gbogbo àwọn templars tó wà ń bí o. Mo fẹ́ ṣe 50th birthday mi, they are all invited.
Oh, really?
Àwọn ọ̀rẹ́ máa fún ẹ ní gbogbo information yẹn. Yeah, August ni o, August 15th.
It is so close. Okay, a máa pe àwọn tiwa aládùúgbò yín nìyẹn then.
Yeah, bá mi pè wọ́n dákun.
August 16th. Ṣé you still know me, àbí?
15.
Okay, 15.
Yeah, August 15th.
Yeah, what's the matter? Right? Drop us in your comments and you'll come and pick it up.
Okay.
Yeah, why not?
Okay.
It's just that
no problem.
August is so close. Anyway, can you nice one, Sha?
I know.
Happy birthday in advance.
I thank you, Jerry.
Bless
yeah.
you, ma.
Thank you.
Yeah, you too. Mama.
Yeah, you too.
Yes, ma. Take care.
Bye-bye.
Interesting. So, please, we have another caller. Our time is almost running out, of course, but we can always continue another time. Here, hello.
Hello.
Hello, sir. Can you hear me?
Yeah, good afternoon, Mr. Mayeku.
Good afternoon to you. How are you, sir?
How are you? I'm fine.
I am too. Please, everybody can hear you.
Okay, I can see it on your face. Calling you from Ghana.
From Germany, did you say?
Ghana.
Oh, Ghana. I was looking at that number as well. How are you, Baba?
I'm okay. Doing great.
You may need to speak up or probably get the phone closer a bit.
For a very long time.
Yeah?
I said I've been watching your program for a very long time.
Oh, thank you. Now, it's better that way. It's clearer now.
You are doing great.
Thank you. Great. Thank you, Baba.
I just want to thank you for what you are doing.
Thank
it's
you.
It's a good job for enlightening all the whole Nigerians all over the world. About Nnamdi Kanu case,
Baba?
I believe they don't want to release him, 1, 2, because he knows more than them. And they are finding out the things he knows. How did he know it? How did he get all those information? or what he knows. So those are the reasons why they are keeping him.
You know what somebody told me?
Let him go.
You know what somebody told me, and I've been thinking of it for a long time. When Bokwari was there, we thought they were hasting things up, right? To capture this and that. Once Bokwari is gone, all this their nonsense will disappear. I don't know how many people will remember or felt that way, because I probably felt that way somewhere, right? However, since Bokwari left, it seems the attacks, the terrorism and all of that keeps growing. Even though APC is doing everything to, to downplay it, to make it look like it's not that bad. Sure you get. But the insecurity keeps growing. So when I was like, that person said, do you not know that there are so many people right now that never ever believed Nnamdi Kanu until this whole thing happening now? And so many of them are saying it publicly. That don't you know that a free Nnamdi Kanu is a threat to God knows whatever agenda they are pushing with this terrorism that seems not to be ending anytime soon? Because there's a chance that a free Nnamdi Kanu will use a different approach now. Sure you get, to counter this terrorism and the advancement of this Fulani terrorism. A new approach where people are likely going to listen to him more now that this whole thing is happening. And people that will be listening to him, they are going to be far, 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 far beyond just the Biafrans. And that's a threat that could throw Nigeria into. Somebody said that is why they can't just let him out there. Once it's no longer in their vicinity, that is out there. This is not going to be like 2015, 2020 anymore.
If you watch it too, what Burkina Faso are doing, what the Nigerians are doing, you can see that there's no lineage for them to be able to use some other country to fight the Biafra war. It cannot be able to be possible. You understand? And the propaganda of the news of all the lies that we're telling is being blowing out every day on social media.
Yes.
I will applaud you to do us a favor, to plead to the Yorubas to get to understand that their life has been shortened, being used as a gamble for their own gain reason. Look at what Wiki is doing now. Why don't he include those lands to the Yorubas?
Because it's never, that is why I keep telling people there is only a stupid person that will be fighting this tribal ethnic nonsense and put it on his head. Yoruba this, Igbos that, Yoruba this, Hausa this, Kinekoda. It's only stupid people, and there are so many stupid people. The criminals in Nigeria, they are from all the tribes in Nigeria. They are united. They don't have religion. They don't have a tribe. They don't have ethnic. They are united. When they loot, they share the money among themselves, not for their people. Right?
Of course.
So so me that is not benefiting from what Tifnubu and his gang are doing, I will come carry basket, I will come up clothes, wear baskets. They shout, say anybody that talk anything about Tinubu is abusing Yoruba. Won't I be looking stupid? So like you said, to answer your question, the land they are sharing, they've given the ones that belongs to the Yoruba among them, they've given them. And that is why I mean, like Tifnubu, his family member, his wife, or some of his appointees, so as Wiki allocated 40,000 plot for his own son, you can imagine what he gave to others. And they are not, none of them is going to be benefited by any Yoruba or any Igbo or any river. I mean, anybody from rivers, anyone. But these rogues. Baba.
Thank you very much for
God bless
your
you.
enlightenment of what you were.
Thank you so much, Mazi. You have a very good one, okay?
You are doing great.
Stay safe.
You are doing great. And one thing I want you to do,
yes,
if
sir,
you can help us to make us to be united with the youth.
Sorry, I missed that one. Your voice is so faint.
I say, if you can help us
to
to be united, we the youth to be.
That's what I'm trying to do, but even me we are there yourself, where they try to be, where they try to be the bridge.
Useful and terrorism, because I believe they are no more than 20.
They are no more than us.
They are not going to be up to 20 million.
It is our weakness. Our division is our weakness. And you know what they say, unite, Baba Mazi?
If we can go unite and go into the forest,
yep,
and we'll chase that, we'll wipe them away from the whole forest. And to them who are using them, those who are using them, who are giving them their false hope of agenda, they want to conquer Nigeria, should be wiped up away. One thing Wike doesn't know is that he should go and ask Abiola. All the
West way we say, and they call Abiola kingmaker. There is no coup, we no fund.
Okay.
But when the boys, khaki boys, we in the fund, when they decided to blow his own ego, we are all witnessing what happened now, Abi. We all witnessed that.
What of the loot? Abacha loot. Where is it today? Wicked is not smart.
It's just a matter of time.
It's not smart.
No.
Where we all witness Abiola, we all witness Abacha. Where are they today? They are all gone.
And we also witnessed the almighty Obasanjo, the man that could have put Nigeria back on track. But here we are. Today now he has even stopped writing letters. Remember that he used to write letters?
He can't make any statement that will be relevant.
Nobody counts them anymore. Obasanjo Almighty.
Almighty Obasanjo.
Mazi.
They should go and sit down and stop stealing. They should stop stealing. Stealing, you will still lose it. If all what this guy, this Colombia guy, the drug dealer, to do, Escobar to do, where is it today? If you stop doing all this rubbish, the top Nigeria belongs to them.
Bless you, Mazi.
Let
me take another one.
Thank you.
God bless you, Baba. You enjoy your afternoon, okay? So I am thinking of taking just one more call, but our 2 hours is quite up already. So maybe we should go get ready for the evening, because we are talking about saying something about with a weekend there. So part of what we are going to be, sharing tonight is going to be the same with a weekend and Afubara. They said they have settled their rift and they are going to be working together. So whatever Fubara disagreed on back then, it seems to have agreed now. So everyone should go back to Sandy Riverians, like people of River State. We'll say good luck to you. So I'll see everybody later this evening. Let me go get ready. So thank you so much for your time. So everybody scanning my, what have you, it is only for the afternoon, okay? If you do really want to reach out and support Mayegu, just, check out there for that link. So it's called Buy Me a Coffee. I'll see you again. Good afternoon.
Mayegun làwa mọ̀ làmọ̀ tó dòdòdò. Mayegun dayari Mayegun number one. Mayegun làwa mọ̀ làmọ̀ tó dòdòdò. Mayegun dayari Mayegun number one. Mayegun ti dé o ọ̀rẹ́ ará ìlú. Mayegun dayari Mayegun number one. Lórí Facebook, lórí YouTube. Mayegun dayari Mayegun number one. Gbogbo bó ṣe ń lọ ni Mayegun já wa sí. Mayegun dayari Mayegun number one. Àṣírí ọ̀jẹ̀lú kì í bò níbẹ̀ o. Mayegun dayari Mayegun number one. àní Máyégún máa wí. Máyégún diary na ibi number one. Ó sì tún ṣe eré wàá gbọ́ níbẹ̀ o. Máyégún diary na ibi number one. Máyégún diary politico. Máyégún diary na ibi number one. Godfatherism kò sí lọ́rọ̀ Máyégún. Máyégún diary na ibi number one. Ẹ farabalẹ̀ sẹ́ o kẹgọ́rọ̀ lẹ́nu o. Máyégún diary na ibi number one. Àní Máyégún làwa mọ̀ tó dódòdó. Máyégún diary na ibi number one. Àní ẹ̀sùn ràkì. Máyégún ti dé. Máyégún ti dé. Ọ̀jẹ̀lú ẹ̀sùn ràkì. Máyégún ti dé. Àní ẹ̀sùn ràkì. Máyégún ti dé. Lórí Facebook. Máyégún ti dé. Àní ẹ̀sùn ràkì. Máyégún ti dé. Lórí YouTube. Máyégún ti dé. Àní ẹ̀sùn ràkì. Máyégún ti dé. Bọ́ bàbá gbé wúrẹ́. Máyégún máa wí. Àní ẹ̀sùn ràkì. Máyégún ti dé. Ijó ìgbádìyẹ. Máyégún máa wí. Àní ẹ̀sùn ràkì. Máyégún ti dé. Bí pẹ̀sìdó bá rúfin o. Máyégún máa wí. Àní ẹ̀sùn ràkì. Máyégún ti dé. Bí gómìnà kówó jẹ. Máyégún máa wí. Àní ẹ̀sùn ràkì. Máyégún ti dé. Ọlọ́pàá tí ń darí bá. Máyégún máa wí. Àní ẹ̀sùn ràkì. Máyégún ti dé. Aṣòfin tí ń rúfin o. Máyégún máa wí. Àní ẹ̀sùn ràkì. Máyégún ti dé. Òpùrọ́ olóṣèlú. Máyégún máa wí. Àní ẹ̀sùn ràkì. Máyégún ti dé. Ọ̀jẹ̀lú ẹ̀sùn ràkì. Máyégún ti dé. Àní ẹ̀sùn ràkì. Máyégún ti dé. Máyégún ti dé. Gbogbo ọ̀jẹ̀lú ẹ̀sùn ràkì. Máyégún ti dé. Gbogbo ọ̀jẹ̀lú ẹ̀sùn ràkì. Ṣùgbọ́n ní bá ti ṣe èyí tó yẹ kí wọ́n ṣe, ọmọ bá dèrò ní fi wọ́n níran o. Máyégún ti dé. Gbogbo ọ̀jẹ̀lú ẹ̀sùn ràkì. Máyégún ti dé. Gbogbo ọ̀jẹ̀lú ẹ̀sùn ràkì. Ṣùgbọ́n ní bá ti ṣe yìí tó yẹ kí wọ́n ṣe, ọmọ bá dẹ́rọ̀ ò ní fi wọ́n níran. Wọ́n fowó bẹ́ẹ̀ o. Máyégún ó sọ pé wọ́n ò bẹ́ẹ̀. Wọ́n fowó bẹ́ẹ̀. Máyégún ó sọ pé wọ́n ò bẹ́ẹ̀. Oníkan ṣáàtì ṣe èyí tó yẹ kí wọ́n ṣe fáwọn ará ìlú tó gbé wọn débẹ̀ o. Ayé. Máyégún ti dé. Gbogbo ọ̀jẹ̀lú ẹ̀sùn ràkì. Máyégún ti dé. Gbogbo ọ̀jẹ̀lú ẹ̀sùn ràkì. Ṣùgbọ́n ní bá ti ṣe yìí tó yẹ kí wọ́n ṣe, ọmọ bá dẹ́rọ̀ ò ní fi wọ́n níran. Kì máa yí ṣeré, ọ̀rọ̀ yìí kì í ṣẹ̀fẹ̀. Kì máa yí ṣeré, ọ̀rọ̀ yìí kì í ṣẹ̀fẹ̀. Ẹni bá ti lè lẹ́bọ̀ lẹ́rù o, ọmọ bá dèrò kàṣàyè tú wọn síta. Máyégún ti dé. Gbogbo ọ̀jẹ̀lú ẹ̀sùn ràkì. Máyégún ti dé. Gbogbo ọ̀jẹ̀lú ẹ̀sùn ràkì. Ṣùgbọ́n ní bá ti ṣe yìí tó yẹ kí wọ́n ṣe, ọmọ bá dẹ́rọ̀ ò ní fi wọ́n níran. Tẹnitẹni ọmọ Máyégún ọ̀rẹ́ ara ìlú mọ̀mọ́ ni. Mo fọlọ́hún ṣọ́ ẹ̀ bá kìlẹ́bù. Lóòótọ́ olódodo ìlú ọ̀tá ìlú mọ̀mọ́ ni. Ìwọ ṣá máa ń ṣọ́ra kò sì mọ́ bẹ̀rù. Bọ́tà ń lè rí bóníṣègùn lé káwọn mọ̀mọ́ fi ṣera wọn ni. Ó ti dẹrùn tí wọn ò gbọ́dọ̀ sè mọ́bẹ̀. Èèpo ọ̀gọ̀ lọmọ bá dérò tàjẹ́ ò gbọ́dọ̀ jẹ́. Ó ti jọba lórí àbínú ẹni kò sì mọ́ bùyà. Àìsíwọ̀lú ní ẹnìkẹ́ ìgbódì ẹyin lábàrá o. Ó kó ẹni tó bá dán wò á kàmù. Máyégún ti dé. Gbogbo ọ̀jẹ̀lú ẹ̀sùn ràkì. Máyégún ti dé. ẹni bá ti ṣe èyí tó yẹ kí wọ́n ṣe ọmọ bá dèrò òní fi wọ́n níran o.
ayégun ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kí. ayégun ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kí. ṣùgbọ́n ní bá ti ṣe èyí tó yẹ kí wọ́n ṣe ọmọ bá dèrò òní fi wọ́n níran.